We'll hear argument next to number 01-1127, Bill Lockyer versus Leandro Andrade.
California's three strikes law was designed to protect the public safety by ensuring longer prison terms and greater punishment for repeat felony offenders. Under the three strikes law, a defendant who's convicted of a felony and has previously been convicted of 2 or more serious or violent felonies must receive a sentence of at least 25 years to life in prison. While on parole from a 9-year prison term, the petitioner stole 3 golf clubs worth nearly $400 apiece.
If any sentence is grossly disproportionate, it's that which was imposed on Leandro Andrade. Today, the state of California asks this court to disregard and essentially to overrule a century of decisions that have held that grossly disproportionate penalties violate the Eighth Amendment.
The purpose of three strikes take off of the streets that very small proportion of people who commit an enormously high proportion of crimes. I forget what the statistics are, but it's something like, of those convicted, 20% commit 85% of the crimes. It sounds to me like your client is a very good candidate for that law.
I agree on the merits that we can't convert this court into a sentencing commission. It's also true, I guess, that there must be some way of deciding when a state has gone too far.
I think that what the court can say is that his prior crimes are relevant in the sense that they make this crime a more aggravated crime than a crime committed by a first offender. And that there can be a reasonable enhancement for that, but in this case, he has been sentenced to, his sentence has gone from a maximum of 3 years for a first offender to life, all based on the recidivism.
Why can't the state say that where a person has a string of convictions like this man has, that it's time to get him off the street, as Justice Scalia says, that he simply cannot conform to the law? There's always going to be some state that punishes more harshly than others.
Your Honor, it's still stealing 3 golf clubs. It's not robbery, rape, murder, or something of that nature. I mean, it is still there. To raise your question, what if someone had a long history of jaywalking?
Supposing the offense was speeding, and it can be a dangerous speeding, and you said that 15 arrests for speeding. It gives you this very sentence we got in this case. Would that be permissible, do you think? Just on the theory that Justice Scalia is, this guy's just too dangerous, we just don't want him on the street anymore, so put him in jail for life.
The opinion of the court in 2 cases will be announced by Justice O'Connor.
I will announce first the opinion in Ewing versus California, number 016978. The case comes on writ of certiorari to the Court of Appeals of California's Second Appellate District. The California Court of Appeal affirmed, concluding that petitioner's sentence did not violate the Eighth Amendment's prohibition on cruel and unusual punishments. In an opinion filed with the clerk of the court today, we affirm the California Court of Appeals decision.